The Shannon Sharpe situation, one of the biggest stories for anyone who pays attention to the NFL, and for good reason. Hall of Fame tight end and a very popular and successful media personality. As the case continues to unfold, and he was sued for sexual assault and other claims over the weekend, he's been very clear. He denies everything. And his lawyer has come out and admitted that a $10 million offer, at least $10 million offer, was made to settle the case before it became public. Now we're getting to the point where it's having an impact on his current employment. Sharpe announced yesterday he'll be stepping aside from ESPN until the start of the NFL preseason. He currently, or at least was, appearing on First Take twice per week, Monday and Tuesday. That's over until the start of the NFL preseason, assuming ESPN even allows him to return. Because Deadline.com reported that ESPN was going to sideline him, and Deadline was about to report that. Boom, Sharpe pivots, and he voluntarily steps aside. There's a PR game to all of this, and I'm not trying to say that Sharpe walked before they made him run, but you could come to that conclusion if ESPN's getting ready to bench him maybe beyond the start of the NFL preseason. None of this is surprising, though. It took on a different vibe when it was disclosed that he offered $10 million. And I know that his lawyer, Lanny Davis, strenuously objects to my characterization that it's very hard to reconcile a loud insistence of innocence with, I offered at least $10 million to settle the claim. But when you hear that kind of number, I think it raises the stakes for ESPN and anybody else that's going to do business with Shannon Sharpe. And then you throw on top of it, Front Office Sports reported on Thursday that there was an incident at Fox when he was working for FS1. Now, the report was that there was an alleged choking of a female coworker. Sharpe's representative said there was no choking. It was playful interaction, but there was reportedly a settlement. And it's unclear when that happened, but this is what occurs when the cat gets out of the bag. Media starts looking for other things. I see there's already some other report. I haven't had a chance to take a look at it yet, but there's going to be more. And you just wonder what kind of impact it's going to have. And I don't know that $20 million instead of $10 million would have settled the case and kept all this stuff from coming to light. I really don't know. But the fact that $10 million was put on the table, that still continues to be significant. I saw someone talking about the $10 million offer in analytical, objective terms, that this is what you do when you try to put a settlement value on a case. She wants $50 million. You've got a certain percentage chance you're going to win or lose. You've got a certain amount of legal fees. So you justify as a business proposition offering $10 million. I don't think that was it here. In a lot of cases, there are specific dollar figures that attach to the damages. If there's a car accident, the medical bills, the lost wages while you miss work, those are all clear, undeniable expenses that were incurred by the car accident. And that becomes part of the foundation for determining the settlement value of the case. For something like this, where there's no bill that was paid, no wages that were lost, no special damages, I know the complaint refers to $10 million in special damages, but it's just numbers that Tony Busby threw together. $10 million in general damages, $10 million in statutory fines, whatever those are, $10 million in special damages, $20 million in punitive damage. You can put any number you want. It's going to be what the jury ultimately gives you. So this isn't some careful mathematical exercise where, well, she wants $50 million and our percentage of prevailing at trial based upon the current trends for juries in Nevada, and it's going to cost whatever to defend the case. This is a pretty simple case. I don't know how much lawyers are charging now. I saw someone suggest it's going to be $8 million to defend them. Maybe I should say see you later and go back to practicing law. It's a pretty simple case. You got two main witnesses. It's not going to take a whole lot of time to prepare this case for trial. There's going to be a whole lot of pre-trial motion practice with long, lengthy documents and legal research. I'd say at the very most it's $500,000, and even then, That's putting the thumb on the scale a little bit, in my opinion. But if it's anywhere close to $8 million, you may never see me again. I'm going to do a little research over the weekend. Maybe it behooves me to go back to practicing law. And I don't mean to make light of the situation, but this is part of the overall analysis. I believe that disclosing the $10 million that was offered to the plaintiff before she filed the lawsuit was a tactical error. It was a PR blunder because the average person, I don't believe, can say, I understand why you'd offer that kind of money to fight a blackmailer, and I understand why you would tell the world that you did it. That's the bigger flaw. It's one thing to do it. It's another thing to say, hey, I offered $10 million to this person who I think is blackmailing me over a completely false claim. I just don't think that's how a reasonable person or most reasonable people would handle that type of a predicament. So we'll continue to follow the case. We'll continue to update it here as warranted. And we hope you continue to check out everything we have at ProFootballTalk.com. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.